I'm going to try that again because I'm not sure it picked me up. Welcome. I'm Nathan Kotkamp with the Healthcare Department at McGuire Woods. I sit in the Richmond office, and joining me today is Lauren Ramos, also with the Healthcare Department. And we are kicking off today a monthly HIPAA webinar series. We get a lot of different questions. We field on an almost daily basis various issues about HIPAA, and thought we would share some of our knowledge with you, starting, of course, with just the basics. I'm pleased to say that this webinar is going to be recorded. CLE is going to be available, and if you want to review it at another time, or if you want to pass it along to a colleague or somebody else, it will be on our website, as is a list of the other monthly HIPAA webinars that we're going to be doing, and we're going to be covering a broad array of topics on HIPAA. But the purpose of today's presentation, as I mentioned, is to really get just a high-level understanding of what HIPAA is all about. There's a lot of confusion out there. HIPAA seems in some sense like it's omnipresent, and it covers everything that has to do with healthcare, and the reality is it doesn't, and we want to be sure that people understand, in particular, when it does and doesn't apply, and it can pop up in some surprising places, and it cannot apply in some places that a lot of people think are fairly obvious. So we're going to be talking about the basic understandings of the privacy and security rules. Again, we're going to be taking them all pretty high level. We've only got an hour here today. We're going to talk about the types of entities to which HIPAA applies. And we're going to be talking about some situations when it doesn't apply, and we'll talk about some best practices. And obviously with all of these things, where there are detailed questions, you are more than welcome to reach out to me or to Lauren or anybody else on the HIPAA team at any point. Our contact information is going to be at the end of the slides. And there is a Q&A option for this webinar, so if you have questions, please feel free to post them. If we don't get to them during the presentation, we'll be sure to circle back with you later on. So I always like to get started with a little bit of HIPAA humor, because there isn't that much humor in HIPAA, but it also helps us to keep in mind a key component of HIPAA at the outset. So our professor here is reminding us that no, we're not dealing with a female hippopotamus. But as you see, it's not HIPAA with two P's. One of the best ways to make yourself look ignorant about HIPAA is to misspell the acronym. It is HIPAA, which stands for the Health Insurance Portability and Accountability Act of 1996. And again, we'll talk a little bit more about that later on, but starting with the right word, the right phrase is absolutely essential. So when we break down the HIPAA rules, and the HIPAA rules that we're talking about here talk about health information. It's part of a much larger regulatory regime about how it is that health insurance gets transferred from one provider to another, particularly when people change jobs. So this is just one piece of that much larger law. But what we're focusing on are four regulatory rules. The first is the privacy rule, and this is the rule that establishes the parameters and the structure about how protected health information, which we'll define in a second, gets to be used and disclosed. And frankly, when you think about HIPAA as a member of the general public, this is what most people are thinking about. It's confidentiality-based rules. It's restrictions you can only use with authorization unless an exception applies. That is really at the core of the privacy rule. The second is a security rule, and it is establishing standards for protecting electronic protected health information, although certainly the rules are a little bit broader because it does take into account some of the physical attributes of the entity, such as how you lock your doors and where you keep your workstations and things like that. But technically speaking, it is limited to electronic protected health information. The third is a breach notification rule, and this was added to the HIPAA regulations back in 2009 because it was recognized, obviously, if there's an issue with either the privacy rule or the security rule, sort of inappropriate use or disclosure, or if there's been a breach of an electronic system, the affected individuals really should be put on notice so that they can protect themselves or take steps to maybe mitigate the risk to their identity or other issues. So the breach notification rule requires written notification in the event of a breach, and we'll talk a little bit more about that as well. And then finally, there's an enforcement rule. This is law, and so it carries with it the potential penalties of both civil money penalties as well as criminal penalties, which we'll talk about as well. So the biggest change to the HIPAA regulations after they were originally adopted in 2002 for the privacy rule, 2003 for the security rule, came in 2013. It was commonly known as, and you'll see it oftentimes written as, the Omnibus final rule, which were regulations responding and implementing the HITECH Act of 2009. And very, very significantly, all of the compliance requirements that are relevant under the Omnibus final rule have come and gone. They were September of 2013 and September of 2014 for a few business associate related matters. But very, very significantly, in addition to the fact that they're now fully in place, and I don't think that there's any room for saying, oh, they're still new and so we're getting up to speed. I think the compliance expectations of the Office for Civil Rights, which enforces these rules, is that we all need to be knowing these rules. They've been around now for 5 years. So, but very, very significantly, among other things, what the Omnibus final rule did and the HITECH Act did was to expand the potential for direct liability to business associates as well as subcontractors. That's a big deal for those of us that get downstream protected health information in our roles as lawyers. Obviously, we do that here at McGuire Woods, but accountants and other consultants and things like that, it makes a big deal when you're thinking about compliance when you can have these potentially happen to you. So these are the penalties. They can range anywhere from $100 per violation up to $1.5 million maximum per violation per year, with criminal penalties of up to $250,000, and the potential for imprisonment. Most of the time what happens is HIPAA matters get settled, in part because these numbers can blossom. And if you think about how complicated the regulations are, if you're in violation of one thing, it's very possible you're in violation of a dozen or more things. And so these penalties could easily raised to very high amounts. And so most of the time what we see in terms of enforcement are settlements, the record settlement being a little over $5.5 million, and most of them coming in the several million range. But there's a wide array, and pretty much no type of provider is immune from an enforcement action. I like to show this because it's just too good not to show. This is a guy named HIPPLER. Yes, we're talking about HIPAA, and he's got two P's in his name, but it's close enough, so work with me here. But Mr. HIPPLER, Joshua HIPPLER, is wearing the jumpsuit that you saw because he's serving an 18-month prison sentence for stealing records from the hospital where he worked and trying to sell them for I think on the black market or some other way to have personal gain. So it doesn't happen very often, but it is helpful to understand that on occasion people do go to prison for HIPAA violations. So hopefully that gets people's attention. So after the Omnibus final rule, who's required to protect PHI? Who's covered by HIPAA in the first place? So there are actually, for as expansive of a law as it is perceived to be, there are actually only three categories of covered entities. The first being healthcare providers, and this is a broad array of healthcare providers: hospitals, physician practices, dentists, pharmacies, lots of different healthcare providers. The next are healthcare plans and health insurers, and this can include, and very significantly, employee health plans. From a non-healthcare provider, the employee benefits program that is obviously typical of the way that we deliver insurance to the workforce in the United States, those health plans sitting with another organization count as health plans covered entities, and they are required to comply with HIPAA even if the rest of the organization does not. And the last are these things called healthcare clearinghouses. They're really billing processing services. There aren't that many of them, and frankly, you probably don't have to worry about them all that much. The other category of entities that fall within HIPAA are these things called business associates. And I mentioned already, lawyers are a category of business associates. They're any individual or entity that provides services on behalf of a covered entity or another business associate, because you can have multiple layers of contractors here that require the entity to create, receive, maintain, or transmit protected health information. So anytime we as lawyers need to have PHI to help serve our clients, many of you on the line, then we are your business associate, and there's an obligation to have a business associate agreement in place. So who's not covered by HIPAA? Well, employers themselves are not covered entities. So as I mentioned, the health plan sort of sits as a legal fiction. It's a silo. It exists as a covered entity for HIPAA purposes, the group health plan, but the entity itself. And there are strict rules that govern the transfer of and uses and disclosures of records and health information from that group health plan to the company that sponsors that plan. But again, the company itself, unless it's a hospital or some other healthcare provider, is itself not a covered entity. Now here's a super important one. And this is one of those, back to the basics, we wanted to dispel any myths about HIPAA. You, as an individual, all of us who are listening in on this and are patients at some point or other in our lives, we are not covered by HIPAA with respect to any sorts of restrictions. We enjoy benefits of HIPAA, where we each enjoy rights that are granted to us as patients under HIPAA. But if I want to share my health information with the world, if I want to post it on social media, if I want to just tell my colleagues at the office what's going on with my health care or the health care of a loved one, that is permitted. I am not restricted by HIPAA as an individual from sharing that information. And similarly, the people who receive that kind of information, so your colleagues or the people that see it on your social media feed, they are not restricted in any way unless they happen to be healthcare providers and it's sort of in that context. But your friends and your family and your enemies can share your PHI and not be worried about HIPAA. Now, there may be other laws they have to worry about, defamation and other things like that can come into play, but HIPAA does not apply to individuals. And we see people get all worked up about, somebody shares a cancer diagnosis, for example, with a colleague at work, and then there's a worry, well, I can't share this, with some of the other colleagues, we can't even send a gift basket or whatever the case may be, and that just isn't the case. So again, really important distinction within HIPAA about the fact that it does not apply to individuals in day-to-day life situations. A little bit more HIPAA humor before we dive into some of the more meaty stuff of HIPAA. Knock, knock, who's there? HIPAA who? Sorry, I can't tell you that. Well, the reality is it's actually not that broad. And HIPAA does, it does provide exceptions that don't fundamentally alter the way that healthcare was delivered before HIPAA, and hopefully doesn't stand as an impediment to the efficient operations of healthcare services. And then, of course, as we know with these kids, they're not covered by HIPAA, so it wouldn't be the case that they would be restricted from telling somebody. So I point that out about our little cartoon here. So I mentioned the concept of protected health information. What is protected health information? Well, it's a very broad definition. It is any information, including genetic information, whether oral or recorded in any form or medium. So that means whether it's on paper, whether it's spoken, whether it's in some sort of digital form, it's all potentially protected health information if it falls in one of these categories. It relates to healthcare, and it's created or received by a healthcare provider, health plan, or healthcare clearinghouse. Those are our list of covered entities. It identifies an individual or contains enough information that would allow someone to be identified. And now here's where it gets super, super broad. It relates to the past, present, or future physical or mental health or condition of the individual, the provision of health care to the individual, or the past, present, or future payment for the provision of health care to an individual. So as you can see, in the context of delivering care, there's very few things that would not fall within that category. And PHI can be created by business associates and received by business associates, so it's really even broader than this, but that's that definition of protected health information. Very, very broad concept. The other thing to understand about PHI and the definition is that it's not as simple as simply stripping out a name, an address, a social security number, things like that, in order for it to be not considered PHI. There's a specific rule within HIPAA called the de-identification rule, and there's two ways to make it happen. One is using a statistical expert, and that doesn't happen very often. Instead, what most people do is they go to the safe harbor list, which is essentially these elements, and as long as every single one of these elements has been stripped out, then information becomes de-identified. And some of these are not intuitive. We talk sometimes internally with our colleagues who need lists of information in a healthcare deal, for example, and all it contains is medical record numbers. And you say to yourself, well, how is that in any way going to identify somebody? I don't, you have to have the code. You have to be an employee of the facility to match a medical record number to the actual diagnostic information that's in the rest of the file. The answer is it doesn't matter. It's in the reg, and because it's in the reg, we are stuck with that being considered PHI. All right. The other thing I will mention, by the way, about covered entities is they have to be engaged in electronic transmission of healthcare information in order to be covered by the HIPAA regulations. So there aren't that many practices out there that operate on a truly cash basis, or it could include credit cards as well. But if that is the case, then actually HIPAA wouldn't apply and state law would. Where HIPAA does apply, I do want to mention, I didn't say this previously, but if there are more restrictive state laws, those laws layer on top of HIPAA. So HIPAA establishes the floor, but certainly not the ceiling. So let's talk a little bit about things that they're not PHI. Employment records. Now this is one where we see a lot of confusion because there are so many cases in which employment records contain health information. But take a step back and think about the context of that information and how it got into the employer's hand in the first place. In many cases, what that health information is information that the employee has disclosed to their employer in the context of showing their qualifications for a job or for a disability claim or accommodation or something of that nature. But remember, individuals are not covered by HIPAA. Ordinary companies are not covered by HIPAA. So that exchange will be covered by various employment laws and other sorts of protections, but it won't be considered PHI and it won't be protected by HIPAA. So similarly, FMLA, disability accommodation, and sick leave requests, those are all things that obviously require the disclosure of certain health information, but they're not PHI because it's not in a healthcare delivery context. Similarly, other employment-related information involving health is not PHI because of the context. So that would be drug screenings, pre-employment screenings, fitness for duty exams, that sort of thing, as well as non-covered benefits, disability insurance, life insurance, workers' comp, and then also de-identified information. As we saw in that last slide, if you strip out all those identifiers, you're no longer dealing with PHI. So what else isn't protected? As we've talked about, information disclosed by individuals about their own health care. And also information that's disclosed pursuant to a valid authorization, because one of the things that's in an authorization is a warning saying HIPAA is no longer going to apply once this is disclosed. Also, anything in response to a court or administrative order, it is no longer protected by HIPAA. It may be protected by legal ethics rules and other things like that, or the court order itself, but HIPAA won't apply, and the same thing is true of subpoenas. So I mentioned this concept of the plan and sitting in a silo, and so just at a very high level, plan sponsors and the plan have to have a firewall between them. You can't be sharing information from a healthcare plan with the employer to do things like validate whether or not somebody's disability request is valid or not. If you need to have health information to validate a claim like that, you need to go and work through the individual, get an authorization from their healthcare to their healthcare provider to have that information released to the employer or the plan sponsor. But there just has to be a very strict firewall there, so something important to point out. Sometimes employees in a benefits group are not only doing benefits administration, but they do, in some smaller organizations, have administrative roles within the entity itself. And in those situations, you almost have to have like a personal firewall, which is not always the easiest thing to do, but I point that out because that is a dynamic that a lot of our clients have to deal with. So appropriate uses and disclosures of PHI sort of tipped us off on this a few minutes ago when I said that HIPAA wasn't supposed to fundamentally alter the flow of information. And that is true because there's not a requirement for authorization or consent, if you will, for three core functions of healthcare delivery. That is treatment, payment, and healthcare operations. So let's talk about those in turn. For treatment purposes, although you may oftentimes be asked to sign an authorization for disclosures to other providers, which is more a risk management sort of thing than anything else, HIPAA itself does not restrict that. So if you go to your primary care physician and they are going to submit a prescription to your pharmacy electronically, no need for authorization there. That is a transfer of information or disclosure of information pursuant to treatment. Same as if they were to send your records to a specialist or vice versa. Those sorts of things are inherent in the delivery of healthcare. We don't go to the patient every single time to ask for consent. Similarly, we have a third-party payment system. So the way that a provider or plan knows what it's paying for is it gets information about the care. And then healthcare operations. This is all the back office stuff. This is all the quality of care initiatives and things like that of providers that we need to have healthcare information, and we don't go back to every single patient that had surgery by a particular surgeon as he or she is being peer reviewed, for example. That's just cooked in to the healthcare delivery system. But otherwise, if there's an authorization from a patient, and we follow the authorization. That's consent. It's sort of the super exception to HIPAA. And then otherwise, without a patient's authorization, certain circumstances, which we'll talk about in just a second here. Discretionary disclosures. Providers in group health plans can disclose certain information to family, friends, and other persons. It is not as restrictive as a lot of people believe it to be the case, but certainly where there is an individual who is participating in the care of a patient, and when there's no evidence that there would be any objection to sharing information about the nature of that delivery of care, providers can use their best judgment and make certain disclosures. Now, that doesn't mean that they just hand over copies of medical records to somebody who is participating in the care, but certainly the coordination of care allows those kinds of sort of lower level disclosures within the HIPAA context. I think this is also one of the reasons that you're allowed to pick up a prescription for somebody else in your household when you go to the pharmacy, for example. So again, there are also other people who are involved in an individual's care. Sometimes it's personal representatives as a result of an advance directive. And then, as I mentioned, the family and friends rule, which is also important. So otherwise, without authorization, we got treatment, payment, and healthcare operations. We also have disclosures to business associates, personal representatives, and family members. So that's sort of the complete list of the exceptions to authorization rule. Otherwise, the exceptions are mostly legal-based, so required by law, public health, administrative, judicial proceedings. These are where discovery and subpoenas come in. Workers' compensation, and the reason for that is that the only reason a workers' compensation case ever gets brought is because the worker is putting their health care at issue and claiming benefits. So if you're going to make that claim, then your health care becomes relevant, and it serves sort of as a waiver. There's certain reporting requirements with respect to healthcare oversight and violence, abuse, neglect, that sort of thing. Law enforcement, although I'll note that the police don't get a right to a complete medical record. They get certain information to identify victims or potential perpetrators of crimes, and a few other things, including averting threats to health or safety. In terms of the rights that we get, and I mentioned this earlier, HIPAA does not apply to us as individuals, but we enjoy several rights as consumers in the healthcare world, and that is, first and foremost, to receive a notice of privacy practices. That's that long document that you are almost certain to be signing off on having received when you go to the doctor, the hospital, the pharmacy, whatever. Most people don't actually read it, but it does actually describe what your rights are. And I do encourage you at some point to read one sometime, particularly if you got a long wait in the doctor's waiting office. Read it. Just learn a little bit more about HIPAA. It's a great way to get educated. Also have rights to alternative confidential communications. So if you don't want mail with PHI coming to your home mailbox, you can direct it to a PO box, for example. You get a right to access copies, including electronic copies, and that's a firmly protected right by the OCR. You get a right to at least request, you don't always get it, a request to make an amendment to your health record if there's an error or something that needs to be supplemented. You get a right to an accounting of disclosures. Who else has gotten it outside of that treatment, payment, and healthcare operations context, if anybody? Also, you can request reasonable restrictions on the use and disclosure. Again, they may not be granted, but you can always ask for them. And you always have a right to file a complaint. And you can't retaliate against people, or you can't be retaliated against if you make a request, make a complaint about HIPAA issues. So we talked about patient authorizations, which again is sort of that big master trump card for the HIPAA rules, and they are specialized documents. So you can't just write a handwritten note or shoot off an email or a text saying, give me a copy of my medical record. It's got to be in writing. It's got to describe what's being disclosed, who's disclosing it, who's receiving it, the purpose. It's got to have an expiration date. It's got to be signed and dated by the patient. And then it also has to include some sort of waiver warning types of language. One, that HIPAA is not going to apply to it later. Two, that you have a right to revoke your authorization at any point. And three, that providers can't condition delivery of care on whether or not you sign an authorization. So those are the core elements of a patient authorization. It's not just as simple as making a straight-up request. I mentioned workers' comp. This is a big exception because of the fact that those types of actions depend on health information to be processed. Employer communication. So PHI can flow from the group health plan to the plan sponsor, so the company, if you will, unrestricted, if it is certain narrow types of information, summary healthcare information. Obviously, the employer needs to know, as it's trying to negotiate with health insurers and things like that, for making premium bids and for modifying or amending a group health plan. And also whether or not the individual is participating in the group health plan. This is necessary for payroll deductions and tax purposes and things like that. So those are the ways in which information can flow to companies, but it is very, very limited. Incidental disclosures. One of the things that we see people get all worked up about in the HIPAA context is that there is information that can sometimes be overheard. This is a big deal about the patient sign-in sheets when you go to your doctor or the hospital. There were concerns originally that you couldn't even have a sign-in sheet because that would violate HIPAA. It doesn't. It's recognized that those types of things, as long as the intake people or the nurses and saying, Mr. Kotkamp, it's time to come back for your fill in the blank, diagnosis or treatment or something like that. If they just say, okay, Mr. Kotkamp, it's your turn to see the doctor, that's okay. So hearing somebody's name, cleaning crews, it's recognized in the guidance that a cleaning crew that comes into the hospital, they're not business associates. They're not there to be looking at medical records. If they glance at a whiteboard that has patient names on it and things like that, it counts as an incidental disclosure, which are to be kept to a minimum. But not every little bit of disclosure of anything related to health constitutes a HIPAA violation. And then finally, there's this sort of overarching rule that's very important to much of the way that HIPAA works, and that is a minimum necessary rule. Where possible, and except in treatment and payment and healthcare operations purposes where broader disclosures may be appropriate. The concept is you only disclose the least amount of information that you need to address the issue at hand. So that's one that's just sort of pervasive in all things HIPAA. And I have covered a lot, and you're probably sick and tired of hearing me for a little while, so I'm going to turn it over to Lauren to talk about some other HIPAA topics here. And, again, thanks for joining us. I'll be back.
Hi, everyone. As Nathan said, my name is Lauren Ramos. I'm an associate at McGuire-Woods here in our healthcare department. We're going to talk a little bit about, Nathan covered a lot of things under the HIPAA privacy rule. So we're going to first talk about kind of what can go wrong and how you deal with that, and then flip over into another section of HIPAA, which is the HIPAA security rule, dealing more with electronic and technological issues of having electronic PHI. So to start out, we're going to talk about breach. As Nathan mentioned, there is now a breach notification rule under HIPAA. And that was added subsequent to most of the things that we're talking about. So the definition of a breach is the acquisition, access, use, or disclosure of unsecured PHI that is not permitted under the privacy rule and which compromises the security or privacy of the PHI. So there's a lot to unpack in this one definition before you even actually get to deciding that you have an actual HIPAA reportable breach. So it's not limited to, a breach isn't limited to somebody taking PHI and going out and, let's say a healthcare provider, and going out and showing it to the world. It can just be acquiring that PHI. It can be someone acquiring your PHI. It can be just someone accessing the PHI who's not permitted to. So, for example, OCR has said that ransomware attacks on your electronic systems can be HIPAA breaches if they meet the other requirements of this definition, because someone is accessing PHI that is protected under HIPAA without authorization. So breach is pretty expansive in that respect. And the second element is that it has to be unsecured PHI. So the definition is right underneath there. PHI that is not rendered unusable, unreadable, or indecipherable to unauthorized persons through the use of technology. So we'll get into a specific example or two of, how you can render your PHI secure. And if your PHI can be deemed to be secure, even if it was impermissibly acquired, accessed, used, or disclosed, then you would not have a HIPAA breach. It has to, of course, be not permitted under HIPAA. And then the key part of the definition is that it compromises the security or privacy of the PHI. And going on to the next slide, how do we decide if the security or privacy of the PHI is compromised? So we do this 4-factor risk analysis or risk assessment to make that determination. And you have to presume under HIPAA that if it's unsecured PHI and it was acquired, access, used, or disclosed in an impermissible way, you have to presume it's a breach. Then you go through this risk assessment to determine if there is a compromise. And you can see the 4 elements laid out here. So if you go through, you take these 4 factors, you plug your facts of your particular potential breach into these factors, and you make a determination of how probable it is that the PHI has been compromised. If you can determine that there is a low probability based on these factors that the PHI has been compromised, then you do not have a reportable breach. You do not have to make notifications and kind of follow the rules that we'll talk about later. If it is more than a low probability that the PHI has been compromised, then you have to go through the breach notification processes. And no matter what, you want to be making sure that in the meantime, you are doing your proper investigation and you are mitigating to the greatest extent that you can any further impermissible uses or disclosures, any harm that you know of this unsecured PHI being accessed or used impermissibly. So you don't want to get so wrapped up in your risk analysis that you're not simultaneously taking the actions that you need to be taking, especially if you end up coming out on the side of a breach after you run this assessment. Going back to what is unsecured PHI, so encryption is something that we consider low-hanging fruit. If you have your systems and your PHI is encrypted in a way that is consistent with federal guidance, then that automatically deems that PHI to not be unsecured. So essentially it is secured if it is properly encrypted in accordance with the federal law. And then you don't have unsecured PHI, so you don't meet the definition of a breach. You don't have to do breach notifications. So we always strongly encourage everyone that we work with to implement encryption to the greatest extent possible on all devices, any transmission of PHI. It's just basically industry standard at this point, and can save you a lot of headache with respect to HIPAA as well. So moving on to what do you do if you have a breach. So covered entities are actually the ones under HIPAA who are responsible for making sure that notification in all the proper processes are followed for a breach. Business associates are not directly responsible for that under HIPAA. However, a covered entity can delegate that function to a business associate in the business associate agreement. Sometimes you will see that in a BAA, that they will work together to make sure that notifications are done, to ensure that they're done correctly, that the notification has the right content. Sometimes the business associate will even be responsible for actually making the notifications, but if there's no kind of agreement to that effect, and even if there is, the covered entity is still ultimately responsible under the law to make sure that it gets done and gets done correctly. So you can see the kind of list here. There are certain requirements. Obviously, the biggest one is to the individuals who have been affected. You have 60 days to do that. If it's more than 500 individuals whose PHI was breached, you have to also notify the Department of Health and Human Services simultaneously within that 60-day period after your discovery of the breach. If it's more than 500 individuals affected in a state, in a single state or jurisdiction, you also have to notify the media in that jurisdiction. And regardless, even if you didn't have 500 individuals in one breach, so you had to do the HHS notification right then, you still have to every year report to HHS all of the breaches that you did have, even if they were fewer than 500 individuals. Usually the business associate agreement will dictate how much time a business associate has to report a breach that is caused by the business associate or at the business associate to the covered entity. You want that to be, at least within the time frame that the covered entity has to make notifications. Usually it's much shorter, so that if a business associate is notifying the covered entity of the breach, they have plenty of time, well within the 60 days, to investigate, to do a risk assessment, to get notifications together and out. So a business associate may have, up to 60 days after discovery to report the breach to the covered entity. We would typically expect to see something more like 5 or 10 business days, somewhere in there, that the parties agree on in the business associate agreement. The bottom line is that if you're a business associate, you want to pretty quickly as possible notify and involve the covered entity in the incident, because there's kind of no getting out of it, and it's better to just collaborate from the beginning. So we have some recommendations if you suspect that you did have a breach. So this is for sort of employees who maybe discover that a patient chart was taken impermissibly, or their laptop, which had access to PHI, is stolen, or something like that. The biggest thing is to immediately report that to the organization's privacy or security officer. So it's really important that all your employees know who those people are and how to get a hold of them for a variety of reasons, but especially if they suspect that there is a HIPAA breach or a security incident. That is basically as far as we want the employee to go on their own. So report it to the privacy or the security officer, and then wait for further instructions. Don't independently do a risk assessment. Don't discuss it with anyone else. Don't report it to any third parties or discuss it. Don't take breach notification into your own hands. Essentially, report it and then stop and wait for further direction directly from the privacy or security officer. And that may be where it ends for you, for the employee who reports it. Or they may need you to cooperate and help with the investigation and some follow-up. But we do not recommend having staff or employees take matters into their own hands. Everything should be streamlined through the privacy and security officer. So if you do have a breach, you have to make all these notifications, and then if you have a large enough breach and you report it to HHS or during your annual reporting, you might call OCR, the Office of Civil Rights. You might call their attention to your organization after a breach, and they might come in and look at, they want to know what happened. They want to know if you had your proper protocols in place. And this was just a breach that happened even if you were completely in compliance with HIPAA. You have all your policies and procedures in place and everything. If that is not the case and they come in and they see that you do not, then as Nathan has already gone over, you are subject to civil and criminal penalties depending on the nature of the breach and the level of compliance or noncompliance that you have. What cannot happen under HIPAA is that a patient whose PHI was breached cannot sue under HIPAA. There is no private right of action under HIPAA. And we just had another court, actually just Friday, come down and kind of reaffirm this. But it's pretty clear in HIPAA, and it's been consistently upheld by the courts, that there's no private cause of action. That doesn't mean you're safe. As Nathan said, you might have state law claims. In tort, specific state privacy laws that might create a private cause of action, but you cannot sue just under HIPAA as an individual who thinks that your privacy rights have been violated. Okay. Now we're going to switch gears a little bit and talk about business associate agreements in a little bit more in depth. So we kind of talked about this in the context of, working together for breaches and kind of dividing up and delegating those responsibilities. But essentially, if you have a business associate of a covered entity, which is a business associate, again, is someone who maintains or creates or uses PHI of a covered entity to provide services to that covered entity, then you have to enter into a written agreement that's called a business associate agreement, or more frequently, you will hear it referred to as a BAA. it basically says that the business associate will safeguard PHI in the same way that the covered entity does and in compliance with the with HIPAA, and that if they don't, they recognize that they're out of compliance with HIPAA, and then also they have at that point they also have a contractual violation as well. Covered entities are responsible for having BAAs in place. If there isn't one in place, and there should be, that's the covered entity's fault and liability. It's not the business associate's fault. So covered entities want to be really careful about that. Any use or disclosure of PHI by a business associate must be within the scope of the BAA. So except as explicitly permitted in a BAA, a business associate cannot use PHI for its own purposes. Usually, standard form of BAI, there's some caveats in there that say a business associate can use the PHI for their administration and legal responsibilities that they have to carry out. But otherwise, the business associate has to really stick within the four corners of what's authorized in the BAA and HIPAA. There's no standard form of BAA. There are plenty of templates out there that you can look for. Actual BAAs vary widely as far as how aggressive they are beyond the HIPAA requirements, how many additional provisions they get into. So HIPAA dictates certain provisions that must be in a BAA, but it's just like any contract negotiation. Parties often go beyond that, and there are a lot of hot button issues that end up getting negotiated, like responsibility for different actions, indemnification, things like that. So it's really important to have a template BAA for your organization that is appropriate for the size and scope beyond the HIPAA requirements, and to train all your employees on what it is, when they need to use it, who to go to if someone won't sign it, and if there are going to be negotiations. Typically employees should not be and aren't authorized to be negotiating a BAA. What do they do in that circumstance? And the privacy officer is the one who should really be reviewing and approving any BAAs if they are going to be negotiated. Oftentimes they will reach out to either their in-house lawyers or to outside counsel. We review BAAs essentially on a daily basis now for our clients. So that should definitely go upstream at that point. Beware that you might have conflicts of interest issues. So clients do have the right, like I said, to have a third-party review of BAAs. So if you're having a third-party review your BAAs, you have to be careful. It's not, even though it seems like a small thing and maybe it's going to be an hour or two of your time, you still need to be aware that you are negotiating a contract between two adverse parties, and there could be conflicts issues there. So some cautions related to BAAs. A vendor is considered to be a business associate based on its activities, not whether it has a BAA in place. And correspondingly, vendors are often asked to sign BAAs in situations where HIPAA isn't applicable. So we see this all the time when people want to disclose PHI for some reason, and it comes up, I would say most frequently in diligence as part of transactions that don't neatly fall into the transaction, or even they do fall into the transaction exception under HIPAA for disclosing that PHI. People just, if they want to disclose PHI, they want to slap a BAA on it, have everyone sign it, and then they think they're good to go. The BAA does not create compliance or permission to disclose PHI if there isn't already a business associate relationship in place that would permit you to in a reason that would permit you to disclose that PHI. So you can't just go around signing BAAs and think you're covered. And if you're a business associate, you want to, so that's from the covered entity side, are you authorized to make this disclosure? And then from the business associate side, you want to be careful that you're not entering into BAAs. We counsel clients on this all the time, that you're not entering into BAAs that you don't have to sign, because there isn't a relationship that creates the requirement for the BAA, and then you're just signing yourself up for extra liability that you don't need. So that is BAAs. Our next little topic is for disclosures in judicial and administrative proceedings. This is a little trickier. When can you disclose if you have a lawsuit or you receive a subpoena? And I will say this is referenced throughout this slide, but a really important facet of this, in addition to HIPAA, is to go to your state law or consult an attorney in the state who is familiar with these rules to check all the state laws that complement HIPAA. So a lot of state laws have very specific requirements in addition that go beyond HIPAA for disclosures in these particular settings. So you can disclose PHI if you have a court order or an order from an administrative tribunal. That can only be the PHI that is specifically authorized in the order. You can disclose medical records or PHI in response to a subpoena, but there has to have been notice to the individual, and then again, go to state law, make sure the time for that individual to object has passed, and make sure all the special state requirements are fulfilled. So, for example, in Virginia, there has to be a very specific statement, disclosure on the subpoena itself. You have to wait a certain number of days, and then after all of those kind of boxes are ticked, then you can respond to the subpoena. You can also disclose it in response to a qualified protective order if it's agreed to by the parties. The protective order limits redisclosure. It requires that the PHI is returned or destroyed once the litigation is over, and it's signed by a judge. Again, on all of these, go back to state law as well. So once PHI is disclosed under one of those circumstances where you're permitted to disclose it, what happens then? Where does HIPAA go from there? So if you've disclosed PHI in response to a subpoena, HIPAA does not apply to the recipient of that information. This is, of course, one of the reasons why the individual has to be notified and given the right to object to the subpoena, because once it's disclosed, it's no longer protected. If it's in response to a court order, it depends on what the order says. So, like we said, we would want to see limitations on what can be done with that PHI once it's produced, but it just kind of depends on what the parties have agreed or what the court specifically says. And the same is with a qualified protective order. So in both of those cases, it just depends on what the order says as far as how much the PHI will be protected after it's disclosed. Okay. So we've, again, covered a lot. The privacy rule, breach notification, permissible uses and disclosures. Now we're going to move on to the security rule. So the purpose of the security rule is to ensure the confidentiality, integrity, and availability of electronic PHI. So you can see there are actually definitions for each one of these. Confidentiality means it's accessible only by authorized people. Integrity means it's not altered or destroyed. And availability means it's accessed as needed only by authorized persons, but authorized persons do have access to it. It must be available to you, to the individual whose PHI is involved. And this applies both to covered entities and business associates. So business associates also have to comply with the security rule and have to meet all of these basic elements as well. you have to conduct a HIPAA risk assessment. That's something you can do internally if you're sophisticated enough and you have people who are familiar enough with your technology and with your electronic systems to complete a risk assessment. There are also third-party vendors who can handle that for you if you would like to put the responsibility on somebody else, and they are experts in that. You have to identify and respond to security incidents. There are, effectively the same as having a breach or an unauthorized use or disclosure of paper, of hard copies of PHI. If you have a security incident where ePHI is potentially breached, then you need to, go through those correct steps. You want to have a backup plan, a disaster recovery plan, and an emergency operation plan. If, say, a ransomware attack happens and you can't get to your ePHI is encrypted, or you have a hurricane and your servers are destroyed, can you still somehow get to that, to a backup, or operate in an emergency mode to still be able to access that PHI, something like that. You have to adopt physical, technical, and administrative safeguards, which are set out in high detail within the security rule, and develop and maintain policies and procedures. So ideally, you should have a set of HIPAA privacy rule policies and procedures, and then also policies and procedures related to security rule compliance. I won't go through each one of these in detail, but you can see some technology recommendations. Just use common sense when you have electronic devices. Protect your PHI as much as possible. At any step of the process that there is the option to use a password for encryption, to have a backup plan, to be able to remotely access a device, to wipe it if it's stolen, not storing PHI on removable media, portable media, and again, just making sure that you're encrypting it, or even if you're going to transmit PHI, even using a secure file transfer system instead of PHI, instead of email, that is encrypted. And one more slide of compliance tips. Nathan went over minimum necessary. Just try to only have the amount of PHI that you absolutely need. Don't discuss PHI with or in front of unauthorized persons. That goes without saying. Remove PHI from plain view. So don't leave medical records laying around. Don't have a computer screen that everyone can see that has PHI on it, things like that. Don't remove PHI from your workplace if that's feasible for your operations. Report unauthorized disclosures promptly, or even I would say immediately, to the appropriate person. And if you're a business associate, just be in constant coordination with the covered entity with all of your HIPAA compliance as far as any issues that may come up, but especially in the event of a breach. So I'm going to stop there and give Nathan the last minute to kind of wrap this all up.
Awesome. Thank you so much, Lauren, and thanks for everybody sticking with us. Just to give you a little nutshell here, the formatting's a little bit screwed up, but just to remind what we've been through today, the privacy rule is sort of the broadest set of rules, and then the security rule sits on top of that. Breach notification applies to things that fall outside of those rules, and there does need to be training as well as policies and procedures covering all these things. So if you're sort of looking for HIPAA in a nutshell, that is it. I want to just point out that there is no such thing as being done with HIPAA compliance. There is no stamp of approval. There's no certification you get. It's an ongoing sort of thing, and technology evolves, operations evolve. So you need to be doing constant HIPAA vigilance. It doesn't mean it needs to be an overarching, horrible task, but you can't really sort of set it and forget it. And in terms of a top 10 list, I'm not going to have time to go through all these, but again, the slides will be there for you. But just keep in mind, if you even drill the top 10 down to sort of 3 core pillars of HIPAA compliance, it's having policies and procedures, it's compliance with the security rule with respect to risk assessments, and then finally training. So again, As I mentioned, we are more than happy. It's a big team of us here at McGuire Woods that do HIPAA work in addition to me and Lauren, and if we can ever be of assistance to you, here are our phone numbers, here are our email addresses. I really, really thank you for joining us today. I hope that you can join in some of the other monthly HIPAA webinars that we're going to be doing over the course of this year, and have a wonderful afternoon.